Good afternoon, class. Our topic today is about different kinds of obligations. Now, we need to classify these kinds of obligations for us to better understand it, no? Atong himayon. Now, okay, so obligations are being uh, primary classifications of obligations and secondary classifications of obligations. Now, under primary classifications of obligations, we have pure and conditional obligations under Articles 1179 to 1192, obligations with the period Articles 1193 to 1198, alternative under Articles 1199 to 1205, and facultative obligations under Article 1206, joint and solidary obligations under Articles 1207 to 1222, divisible and invisible obligations under Articles 1223 to 1225, and obligations with penal clause under Articles 1226 to 1230. In secondary classifications of obligations, we have unilateral and bilateral obligations under Articles 1169 to 1168, determinate and generic obligations under Article 1165, civil and natural obligations under Articles 1423, and legal, conventional, and penal obligations under Articles 1157, 1159, and 1161. Now, let's proceed to Article 1179. It says every obligation whose performance does not depend upon the future or uncertain event or upon a past event unknown to the parties is demandable at once. Now, every obligation which contain a resolutory condition shall also be demandable without prejudice to the effects of the happening of the event. So, what do we mean by pure obligation? Okay, so pure obligation is one which is not subject to any condition and no specific date is mentioned for its fulfillment and is therefore immediately demandable. So, timan ini siya, kaning obligation walay condition or specific date, no, for its fulfillment. Okay, example, D obliged himself to pay C 1,000. The obligation is immediately demandable because there is no condition and no date is mentioned for its fulfillment. Okay. Of course, if the loan has just been contracted by D, a period must have been intended by the parties for performance, but the duration thereof will depend upon the nature of the obligation and the circumstances. Okay, so take note of that. Another example is when D binds himself to pay C 1,000 upon demand of C. The obligation is immediately due and demandable. Okay, so whenever C demands the payment, D should pay. Okay, take note. What is the meaning of conditional obligation? Now, a conditional obligation is one whose consequences are subject in one way or another to the fulfillment of a certain condition. Okay. Unsa man pud ning condition? A condition is a future and uncertain event. This includes acquisition of proof and or knowledge of a past event unknown to the parties. Okay. Now, characteristics of a condition. Number one is future and uncertain. In order to constitute an event as a condition, it is not enough that it be future. It must also be uncertain. So, dili rang enough nga future, kinahanglan po siyang uncertain. Okay? Now, another characteristic of a condition is past but unknown. So, ning labay na siya pero unknown, wala mahibaw eh. A condition may refer to a past event unknown to the parties. If it refers to a future event, both its occurrence and the time of such occurrence must be uncertain. Otherwise, it is not a condition. Kung mayon kag uncertain, meaning walay klaro, no? Either mahitabo or either dili. Now, a condition must not be impossible. So take note of this. Mohatag gani og condition, dapat dili imposible. Okay? Note that for the first kind, Article 1179 uses the phrase future or uncertain. It must be construed as and, so dili or. Okay. Now, there are two principal kinds of condition. One is suspensive condition. Suspensive condition is condition precedent or condition antecedent. Now, obligation shall only be effective upon the fulfillment of the condition. That's under Article 1181 of the Civil Code. In other words, the demandability of the obligation is suspended until the happening of the uncertain event which constitute the condition. The obligee acquires a mere hope or expectancy protected by law upon the constitution of the obligation. So, dili pa niya maiyaha ang butang, for example, no? Mere hope pa na. Expect pa siya nga maiya. Example, I will sell you the land if it is adjudicated to me in the division of my deceased father's estate. My obligation is demandable only after the condition is fulfilled, my becoming the new owner of the land. In the meantime, I am not liable to you. Okay? Mere hope pa, expectancy pa ang gina-protect ani sa balaod. So, kanus aman niya pwede mabaligya ang land the moment iya na ang uh, estate sa iyang father. So, ma-divide na niya or daghan sila nga heirs. Okay? So, in the meantime, wala pay liability tungod kay dili pa man iyaha ang yuta. Now, rule on fruits in suspensive condition. In suspensive conditions, the effect of a conditional obligation to give retroacts to the day of the constitution of the obligation. So what do we mean by retroact? So mo adto kung kanus at what date no the obligation was being constituted. Nevertheless, when the obligation imposes reciprocal prestations, the fruits and interest during dependency of the suspensive condition shall be deemed to have been mutually compensated. Now, if the obligation is unilateral, the debtor or obligor shall appropriate the fruits and interests received unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same is different. So take note of that. Next kind of condition is resolutory condition. Okay. Resolutory condition is condition subsequent, or the happening of the condition has the effect of extinguishing an obligation. Once the condition is established or acknowledged, the right to demand performance immediately exists, and therefore the obligation can be demanded at once. Example, D, in payment of his debt to C, binds himself to give C 3,000 monthly allowance until C graduates from college. D's obligation is demandable now, but it shall be extinguished or terminated upon the happening of the resolutory condition, which is C graduating from college. Okay. Now, let's distinguish suspensive and resolutory conditions so you will better understand unsa man ni silang duha nga klase nga condition. Okay? The difference between the two conditions is very clear. Both bear an influence on the existence of the obligation, but in diametrically opposed manner. Number one, if the suspensive condition is fulfilled, the obligation arises, while if it is resolutory condition that is fulfilled, the obligation is extinguished. Okay, ani ni ha. Kung suspensive gani ang condition, unya kana nga condition ma-fulfill or matuman, ang obligasyon mo arise. So na you are obliged now to pay or whatever, to do ba kaha ang imong gamiton or to pay, no? However, if it is a resolutory condition ang matuman, ang obligation ma-extinguish, meaning wala na'y obligasyon, no? Mahunong ang obligation. For example, to pay. So kung ang resolutory condition ma-fulfill, then dili na siya mo bayad. Number two, if the first does not take place, the tie of the law or the juridical or legal tie does not appear, while if it is the other, the tie of law is consolidated. So meaning to say, sa suspensive condition, kung ang condition does not takes place, walay obligasyon nga mahitabo. Okay? It does not, the legal tie does not appear. However, if the resolutory condition ang mo take place, the tie of law is consolidated. Until the first takes place, the existence of the obligation is a mere hope, while in the second, maghisgot ani sa resolutory condition, its effect flow but over it hovers the possibility of termination. So again, kung ang suspensive condition mahitabo, there the obligation to pay or to do or whatever obligation that is would exist. While ang resolutory condition ang mahitabo, then ma-extinguish ang obligation. Okay. Now, when can we say that an obligation is demandable at once? Now, an obligation is demandable at once. Number one, when it is pure, when it is subject to a resolutory condition, or when it is subject to a resolutory period. Article 1180. When the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to one with a period, which is subject to the provisions of Article 1197. Now, where duration of period depends upon the will of debtor. So, ang nangutang ang magbot kanus siya mo bayad, no? A period is a future and certain event upon the arrival of which the obligation subject to it either arises or is extinguished depending on the obligation. So ganina sa atong na-mention nga suspensive condition or resolutory condition. 1. The debtor promises to pay when his means permit him to do so. This is the obligation shall be deemed to be one with a period. So, kano sa aman siya mo bayad? Kung naa na siya'y kwarta. Okay? In this case, what depends upon the debtor's will is not whether he should not pay or whether he should pay or not. For indeed, he binds himself to pay. So, dili question kung bayad siya or dili, no? What is left only to his will is the duration of the period. If the debtor and the creditor cannot agree as to the specific time for payment, the court shall fix the same on the application of either party. So, again ha, ang pwede ra na left only to the will of the debtor is the period, but not nga mubayad ba siya or dili. So, kung mangutang ka, kinahanglan kang mo bayad. Other cases, as when the debtor binds himself to pay, like little by little or as soon as possible, from time to time, at any time I have the money in partial payments and when I am in a position to pay. So, pwede rin na siya, class. Mayroon ka nga, kanang anak na ko mo ba, pwede akong tagi-tagihon or bayad ko lagi as soon as possible. No? Or bayad ko until sa katapusan sa buwan. So, make sure unsang buwan na inyong gihisgutan diha. Kay basog katapusan nas buwan nga kanus ang buwan na mahuman. Kay dili ra ba mahuman. Ikaw man sa usa ka buwan na napoy usa ka buwan. So, make sure mahibaw mo unsa ng buwan na. Okay? Article 1181. Unconditional obligations. The acquisition of rights as well as the extinguishment of or loss of those already acquired shall depend upon the happening of the event which constitutes the condition. Okay. So, effect of happening of a condition. So, unsa may mahitabo. Unsa may epekto kung mahitabo ang condition, either suspensive or resolutory. Now, in acquisition of rights, in obligation subject to a suspensive condition, the acquisition of rights by creditor depends upon the happening of the event which constitutes the condition. Now, what characterizes this kind of obligation is the fact that its efficacy or obligatory force, as distinguished from its demandability, is subordinate to the happening of a future and uncertain event, so that if the suspensive condition does not take place, the parties would stand as if no conditional obligations had never existed. So, during the pendency of the suspensive condition, the creditor has only a mere hope or expectancy of acquiring a right because again, wala pa man nahitabo na pa may condition, no? Example. Okay. T, the stator, in his last will and testament, gave some properties to H, provided T would die within 2 years. In this case, H, the heir, would acquire a right to the land only upon the happening of the suspensive condition. So, unsa man tong suspensive condition? The death of T within 2 years. So, what if dili mamatay si T within 2 years? So, dili niya ma-acquire ang land. Okay, so unsa may suspensive condition here? The death of T within 2 years. Another example is the surrender of the sweepstakes ticket is a condition precedent to the payment of the prize. So, di ba, di man ka, kung makadaog kag loto, di man ka, pwede, dili ka bayaran sa imong premyo if dili nimo ma-surrender ang ticket. Okay? So, the suspensive condition here is, of course, to surrender the sweepstake ticket for you to be able to receive the payment of the price. Second is loss of rights already acquired. An obligation subject to a resolutory condition, the happening of the event which constitutes the condition produces the extinguishment or loss of rights already acquired. Example. X binds himself to support Y until Y graduates from college. Here, the right already acquired by Y, the right to support, shall be extinguished or lost once the condition is fulfilled. So meaning, ginasuportahan naman ni X si Y, no, until mo graduate siya college, and the moment mo graduate siya college, mo stop ang support from X. Another example, S sold to B a parcel of land subject to S's rights of repurchase. The ownership already acquired by B under the contract shall be extinguished or lost should C exercise his rights of repurchase. Okay? Then, a lease contract expressly stipulates that R, lessor, may terminate the lease in case his children shall need the leased premises. Here, the happening of the condition depends upon the will of the third person. So, kinsa man is ang uh, children sa lessor or kang ours children. Let's proceed to Article 1182. When the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void. If it depends upon the chance or upon the will of a third person, the obligation shall take effect in conformity with the provisions of this code. Okay, so let's classify conditions. Number one, as to effect. We have suspensive and resolutory. So, unsa tuning suspensive, it's the happening of which gives rise to the obligation, and resolutory, the happening of which extinguishes the obligation. Next, as to form. One, letter A is express. The condition is clearly stated. No? Gina-express, gina-stipulate sa contract or yes, sa contract ang condition. And B, implied, the conditions merely inferred. As to the possibility, it should be possible. No? The condition is capable of fulfillment legally or physically. We also have impossible condition. This is the condition not capable of fulfillment legally or physically. As to cost or origin, we have potestative, casual, and mixed. Potestative is the condition depends upon the will of one of the contracting parties. Casual, the condition depends upon the chance or upon the will of a third person. And mixed, when the condition depends partly upon the will of a third person. As to mode, we have positive and negative. Positive is when the condition consists in the performance of an act, and negative, the condition consists in the omission of an act. As to numbers, we have conjunctive and disjunctive. Conjunctive, when there are several conditions and all must be fulfilled. Disjunctive, there are several conditions and only one or some of them must be fulfilled. And as to divisibility, divisible and indivisible. It is divisible when the condition is susceptible of partial performance, and it is indivisible when the condition is not susceptible of partial performance. Let's discuss potestative condition. A condition suspensive in nature and which depends upon the sole will of one of the contracting parties. So here, either the debtor, the creditor, or the lessor, or the lessee, either one of them. Where suspensive condition depends upon will of debtor, the conditional obligation is void. Where the potestative condition depends solely upon the will of the debtor, the conditional obligation shall be void because its validity and compliance is left to the will of the debtor, and it cannot, therefore, be easily demanded. In order not to be liable, the debtor will not just fulfill the condition. There is no burden of the debtor, and consequently, no juridical tie is created. So, void ang conditional obligation. For example, I will pay you if I want. No? I will pay you after I receive a loan from the bank. I will pay you after I recover what X owes me. I will pay you after I have harvested fish. I will pay you upon the sale of the house which I live. I will pay you the price upon the forest concession you sold me upon my operation of the same. I will continue to lease your property for as long as I need the premises and pay the rent. So, kani tanan class, both the conditions and the obligations are void. The conditions in example 2 to 6, no, are tantamount to a debtor telling the creditor that he would pay his obligation when and if he wants. Kuyaw, no? So, na ko mo bayad kung kanus ako gusto. In example number 7, the continuance, effectivity, and fulfillment of the lease contract depends solely upon the uncontrolled will of the lessee. So, therefore, void yun class ang condition and of course, the obligation. Next is when only the condition is void. If the obligation is a pre-existing one and therefore does not depend for its existence upon the fulfillment by the debtor of the potestative condition, only the condition is void, leaving unaffected the obligation itself. Here, the condition imposed not on the birth of the obligation but on its fulfillment. So, ganina, ang condition o ang obligations are void. So, here, ang condition ra ang void. Okay, an example. D borrowed 5,000 from C, payable within 2 months. Subsequently, D promised to pay C after D sells his car, to which C agreed. In this case, only the condition is void but not the pre-existing obligation of D to pay C. So, dili mawala ang obligation ni D nga mobayad sa 5,000, no? Within 2 months. Okay. Where suspensive condition depends upon will of creditor. Okay. If the obligation depends exclusively upon the will of the creditor, the obligation is valid. Okay, example. I will pay you my indebtedness upon your demand. The obligation does not become illusory. Normally, the creditor is interested in the fulfillment of the obligation because it is for his benefit. It is up to him whether to enforce his right or not. Okay, so ganina, kung ang suspensive condition depends upon the will of the debtor, it is void. Here, kay di pwede nga moingon ka mangutang kanus ana na ko mobayad kung kanus ako gusto. So dili pwede. But here, kung ang suspensive condition depends upon the will of the creditor, the obligation is valid. Okay? You take note of that. Where resolutory condition depends upon will of debtor. If the condition is resolutory in nature, like the right to repurchase in a sale with pacto de retro, the obligation is valid, although its fulfillment depends upon the sole will of the debtor. The fulfillment of the condition merely causes the extinguishment or loss of rights already acquired. The debtor is naturally interested in its fulfillment. The position of the debtor when the condition is resolutory is exactly the same as that of the creditor when the condition is suspensive. Casual condition. If the suspensive condition depends upon chance or upon the will of a third person, the obligation subject to it is valid. Example, where S binds himself to sell his land to B if he wins a case which is pending before the Supreme Court. Where X, a building contractor, obliged himself in favor of Y, owner, to repair at X's expense any damage that may be caused to the building by any earthquake occurring within 10 years from the date of the completion of its construction. Mixed condition. The obligation is valid if the suspensive condition depends partly upon the chance and partly upon the will of a third person. So, example, where X, a building contractor, obliged himself in favor of Y, owner, to repair at X's expense any damage to the building taking place after an earthquake is found by a panel of arbitrators that construction defects contributed in any way to damage. Now, both conditions must take place in order that X's obligation will arise. The decision of the panel, which is considered as third party, must be accepted by Y and X as final unless it can be shown that it was incompetent to act, that uh, in that capacity or was obviously biased favoring X or Y. Where suspensive condition depends partly upon the will of debtor. Exclusive, now sole, makes it clear that conditional obligations whose fulfillment depends upon partly upon the will of the debtor and partly upon the will of a third person or upon chance are perfectly valid. Okay? It is believed, however, that if the compliance with the obligation still depends upon that part of the condition whose fulfillment depends upon the will of the debtor, the obligation is void as it is within his power to comply or not to comply with the same. The situation is the same as if the condition depends entirely upon the will of the debtor. So, kung uh, partly upon the will of the debtor and partly upon the chance, no, valid sa japat. Kung matanawan po that the compliance with the obligation is magdepende gyapon sa will of the debtor, then the same is void. Okay? Take note of that. Article 1183. Impossible conditions, those contrary to good customs or public policy, and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, the part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. Okay. Now, when is Article 1183 applies? Okay, it refers to suspensive conditions. It applies only to cases where the impossibility already existed at the time the obligation was constituted. If the impossibility arises after the creation of the obligation, then Article 1266 governs. Article 1266 states that the debtor in, a, in an obligation to do shall also be released when the prestation become legally or physically impossible without the fault of the obligor. Okay. Two kinds of impossible conditions. One, physically impossible conditions, when they, in nature of things, cannot exist or cannot be done. An example, I will pay you 10,000 if it will not rain for 1 year in the Philippines. So this is physically impossible, no? Di pwedeng dimuwan in 1 year sa Pilipinas. Second, I will pay you 10,000 if you can carry 20 caravans of palay on your shoulder. Still, it is physically impossible. Dili nimo kaya mag-carry og 20 ka caravan nga palay sa imurang shoulder. Next is legally impossible conditions when they are contrary to law, morals, good customs, public policy. Okay. Example. X will give Y 1,000 if Y, 1, will kill Z, so it is against the law. Or will be the common law wife of X, it is against morals. Or will slap his father, no, it is against good customs. Di ka pwede mo sagpaon mo papa. Or will publicly advocate the overflow of the government. So this is against public order. Or will not appear as a witness against X in a criminal case. So this is against public policy. No? So mga legally impossible conditions. They are contrary to law, morals, good customs, public order, or public policy. Let's talk about the effect of impossible conditions. Now, there are two scenarios. Okay, one is conditional obligation void. Impossible conditions annul the obligation which depends upon them. Both the obligation and the conditions are void. The reason behind the law is that the obligor knows his obligation cannot be fulfilled. He has no intention to comply with his obligation. Second is conditional obligation valid. If the condition is negative, that is not to do an impossible thing, it is disregarded and the obligation is rendered pure and valid. Actually, the condition is always fulfilled when it is not to do an impossible thing, so that it is the same as if there were no condition at all. So the negative condition may not be to give an impossible thing. No? So, again, kung ang conditional obligation is having an impossible conditions, then both the obligation and the conditions are void. But here, valid if the condition is negative. So that is not to do an impossible thing. No? Take note of that. Example, I will sell you my land if you do not carry 20 cans of palay on your shoulder. No? I will sell you my land if you do not give me a dog that talks. So of course, wala man, dili man gid kani. Dili man ka carry og 20 cans of palay on your shoulder. And dili mo pud ka makahatag og dog nga motok. Diba? So, valid ang obligation, ang condition lang ang void kay impossible man. The obligations are pure and therefore demandable at once. Only the affected obligation void. If the obligation is divisible, the part thereof that not affected by the impossible condition shall be valid. So, example, I will give you 10,000 if you sell my land and a car if you kill Pedro. The obligation to give 10,000 is valid, but the obligation to give a car is void because it is dependent upon an impossible condition, which is to kill Pedro, which is against our against the law. No, so you take note. Only the condition void. If the obligation is a pre-existing obligation and therefore does not depend upon the fulfillment of the condition, which is impossible for its existence, only the condition is void. Now, example, D borrowed 10,000 from C. If C later agreed to kill X before D pays him, the condition to kill X is void, but not the pre-existing condition of D to pay C. So, naanamandaan ang pre-existing naman ang obligation ni D nga mobayad kang C. Okay? Article 1184. The condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expires, or if it has become indubitable that the event will not take place. So, positive condition. Article 1184 refers to positive suspensive condition, the happening of an event at a determinate time. The obligation is extinguished as soon as the time expires without the event taking place, or as soon as it has become indubitable that the event will not take place although the time specified has not expired. So when we say indubitable, meaning definite na nga, dili na gyud mo happen ang event, no? Now, example, X oblige himself to give B 10,000 if B will marry C before B reaches the age of 23. Okay. X is liable if B marries C before he reaches the age of 23. X is not liable if B marries C at the age of 23 or after he reaches the age of 23. In this case, the time specified before reaching the age of 23 has expired without the condition, which is marrying C, being fulfilled. The obligation is extinguished as soon as B becomes 23 years old. If B dies at the age of 22 without having married C, the obligation is extinguished because it has become indubitable, or it become definite that the condition will not take place. In this case, the obligation of X is deemed extinguished from the death of B, although the time specified, like before reaching the age 23, has not yet expired. So, dili naman yun, definite naman nga dili na mahitabo because kaning namatay man si B, no? Okay. Article 1185. The condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed, or if it has become evident that the event cannot occur. If no time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated, bearing in mind the nature of the obligation. Now, the provision of Article 1185 speaks of a negative condition that an event will not happen at a determinate time. Now, the obligation shall become um, effective and binding from the moment the time indicated has elapsed, um, without the event taking place, or from the moment it has become evident that the event cannot occur, although the time uh, indicated has not yet elapsed. Now, if no time is fixed, the circumstances shall be considered to arrive at the intention of the parties. This rule may also be applied to a positive condition. Example, X binds himself to give B 10,000 if B is not yet married to C on December 30. Here, X is not liable to B if B marries C on December 30 or prior thereto. X is liable to B if on December 30 B is not married to C and if B marries C after December 30. In the latter case, the condition, which is not marrying C, is fulfilled upon the expiration of the time indicated, which is December 30. Suppose C dies on November 20 without having been married to B. The obligation is rendered effective because it is certain that the condition not to marry C will be fulfilled. In this case, the obligation becomes effective from the moment of C's death on November 20, although the time indicated, which is December 30, has not yet elapsed. Okay. Article 1186. The condition shall be deemed fulfilled when obligor voluntarily prevents its fulfillment. Okay. Constructive fulfillment of suspensive conditions. Now, there are requisites for the application of Article 1186. The condition is suspensive. The obligor actually prevents the fulfillment of the condition, and he acts voluntarily. Now, the law class does not require that the obligor acts with malice or fraud as long as his purpose is to prevent the fulfillment of the condition. He should not be allowed to profit from his own fault or bad faith to the prejudice of the obligee. Okay. Example, X agreed to give Y a 5% commission if the latter could sell the former's land at a certain price. Y found a buyer who definitely decided to buy the property upon the terms prescribed by X. To evade the payment of the commission agreed upon, X himself sold to the buyer the property at a lower price without the aid of Y. In this case, it can be said that the due performance by Y of his undertaking, the condition for the payment of the commission, was purposely prevented by X and is deemed fulfilled. Article 1186, however, does not apply if the act of the obligor is in the exercise of a right. Constructive fulfillment of resolutory condition. Article 1186 applies also to an obligation subject to a resolutory condition with respect to the debtor who is bound to return what he has received from the fulfillment of the condition. So let's uh, have this example. X obliged himself to allow Y to occupy the former's house in Manila as long as X is assigned by the company in the province. When Y learned that X would be transferred to Manila, he was able to induce the president of the company to assign another person in place of X. Now, the obligation of X is extinguished because the fulfillment of the resolutory condition was voluntarily prevented by Y. Hence, Y must vacate the house. Article 1187. The effects of a conditional obligation to give, once the condition has been fulfilled, shall retroact to the day of the constitution of the obligation. Nevertheless, when the obligation imposes reciprocal prestations upon the parties, the fruits and interest during dependency of the condition shall be deemed to have been mutually compensated. If the obligation is unilateral, the debtor shall appropriate the fruits and interests received, unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. In obligations to do and not to do, the court shall determine, in each case, the retroactive effect of the condition that has been complied with. Let's talk about retroactive effects of fulfillment of suspensive condition. Number one, in an obligation to give. An obligation to give subject to a suspensive condition becomes demandable only upon the fulfillment of the condition. However, once the condition is fulfilled, its effect shall retroact to the day when the obligation was constituted. Okay? Now, the reason is because the condition is only an accidental element of a contract. An obligation can exist without being subject to a condition. Had the parties known beforehand that the condition would be fulfilled, they would have bound themselves under a pure obligation. Hence, the obligation should be considered from the time it is constituted and not from the time the condition is fulfilled. Okay? In obligation to do or not to do. With respect to the retroactive effect of the fulfillment of a suspensive condition, in obligations to do or not to do, no fixed rules is provided. The courts are empowered by the use of sound discretion and bearing in mind the intent of the parties to determine, in each case, the retroactive effect of the suspensive condition that has been complied with. It includes the power to decide that the fulfillment of the condition shall have no retroactive effect or from what date such retroactive effect shall take effect. Okay, example. C obliged himself to condone the debt of D, his lawyer, should the latter win C's case in the Supreme Court. In this case, upon the fulfillment of the condition, C shall not entitled, unless the contrary has been stipulated, to the earned interests of the capital during the pendency of the condition, as the intention of C is to extinguish the debt. Here, the fulfillment of the condition has the retroactive effect. So the moment C D would win the case of C in the Supreme Court, then it has retroactive effect nga makondone ang debt niya. Okay. Article 1188. The creditor may, before the fulfillment of the condition, bring the appropriate actions for the preservation of his rights. The debtor may recover what, during the same time, has been paid by mistake in case of suspensive. Now, rights pending fulfillment of suspensive condition. Let's talk about the rights of creditor. He may take or bring appropriate actions for the preservation of his right, as the debtor may render nugatory the obligation upon the happening of the condition. Thus, he may go to the court to prevent the alienation or concealment of the property the debtor has bound himself to deliver, or to have his right annotated on the title of the property in the registry of deeds. Rights of debtor. He is entitled to recover what he has paid by mistake prior to the happening of the suspensive condition. This right is granted to the debtor because the creditor may or may not be able to fulfill the condition imposed, and hence it is not certain that the obligation will arise. This is a case of solutio indiviti, which is based on the principle that no one shall enrich himself at the expense of another. Now, note class that the payment before the fulfillment of the condition must by mistake. Okay? Otherwise, the debtor is deemed to have impliedly waived the condition. In any case, he cannot recover what he has prematurely paid once the suspensive condition is fulfilled. Article 1189. When the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. 1. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. 2. If the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. 3. When the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. Number 4, if it deteriorates through the fault of the debtor, the creditor may choose between the recession of the obligation and its fulfillment, with indemnity for damages in either case. 5. If the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. And 6. If it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. Requisites for application of Article 1189. Okay, so Article 1189 applies only if the obligation is a real obligation, the object is a specific or determinate thing, the obligation is subject to a suspensive condition, the condition is fulfilled, and there is loss, deterioration, or improvement of the thing during the pendency of the condition. Okay, let's talk about kinds of loss. Okay, loss in civil law may be 1. Physical loss, when a thing perishes, as when a house is burned and reduces to ashes. Legal loss, when a thing goes out of commerce, like when it is expropriated, or when a thing theretofore legal becomes illegal. Like during the Japanese occupation, American dollars had become impossible since their use was forbidden by the belligerent occupant. Or civil loss, when a thing disappears in such a way that its existence is unknown, like a particular dog has been missing for some time, or even if known, it cannot be recovered, whether as a matter of fact, like a particular ring is dropped from a ship at sea, or of law, like a property is lost through prescription. Now let's proceed to Article 1191. The power to rescind obligations is implied in reciprocal ones, in case one of the obligors should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation, with the payment of damages in either case. He may also seek rescission even after he has chosen fulfillment, if the latter should become impossible. The court shall decree the rescission claim unless there be just cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired the thing in accordance with Articles 1385 and 1388 and the mortgage. Kinds of obligation according to the person obliged. One is unilateral, when only one party is obliged to comply with a prestation or payment. Example, in a contract of loan, the lender has the obligation to give. After the lender has complied with his obligation, the debtor has the obligation to pay. Next is bilateral, when both parties are mutually bound to each other. In other words, both parties are debtors and creditors of each other. Bilateral obligations may be reciprocal or non-reciprocal. Now, reciprocal obligations are those which arise from the same cause and in which each party is a debtor and creditor of the other, such that the performance of one is designed to be the equivalent and the condition for the performance of the other of his own obligation. Example of this is a contract of sale. The seller is a creditor as to the price and the debtor as to the thing, while the buyer is the creditor as to the thing and the debtor as to the price. In non-reciprocal obligations are those which do not impose simultaneous and correlative performance on both parties. In other words, the performance of one party is not dependent upon the simultaneous performance by the other of his own obligation. Let's talk about remedies in reciprocal obligations. Choices of remedies. In case one of the obligors does not comply with what is incumbent upon him, the aggrieved party may choose between two remedies. One, action for specific performance or the fulfillment of the obligation with damages, or action for rescission of the obligation also with damages. Now, rescission is the remedy available to the obligee when the obligor fails to comply with his obligation to abrogate their contract as if it was never entered into, with a right to recover damages. Then, remedy for rescission for non-compliance. The remedy is granted for breach by the other contracting party that violates the reciprocity between them. Now, let's take note that remedies are alternative. Okay, the remedies of the injured or aggrieved party are alternative and not cumulative. That is, he is privileged to choose only one of the remedies and not both, subject only to the exception in paragraph 2, to wit, he may also seek rescission even after he has chosen fulfillment if the latter should become impossible. But after choosing rescission of the obligation, he cannot thereafter demand its compliance. You have to take note of this, class. Okay. Article 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and it shall bear his own, and each shall bear his own damage. Where both parties are guilty of breach. Article 1192 contemplates two situations. First, when the first infractor is known. One party violated its obligation. Subsequently, the other also violated as part of the obligation. In this case, the liability of the first infractor should be equitably reduced. The second situation is when first infractor cannot be determined. Now, one party violated this obligation followed by the other, but it cannot be determined which of them was the first infractor. The rule is that the contract shall be deemed extinguished and each shall bear his own damages. In effect, the court here, class, shall not provide remedy to either of the parties who must suffer the damages allegedly sustained by them. Sa kay dili man ma-determine kinsa ang unang infractor or kinsay unang nakasala, no? Now, questions. Okay, so I hope you understand this presentation. Okay, so next meeting we will discuss um, obligations with a period. Okay. Okay. This is for your assignment, no? Para ni next meeting. Explain or state briefly the rule or reason for your answer. Okay. B, the debtor borrowed 20,000 from C, the creditor, payable on or before August 30. Before the arrival of the due date, C agreed to the promise of B to pay C if B wants. Can C insist that B pay not later than August 30? And number 2, S, seller, agreed to sell to B, buyer, a specific car for 200,000. Delivery of the car and the payment of the price be made on June 15. Suppose S delivered the car on June 15 but B failed to pay the price. What are the remedies of S? Okay, so you work on this November 22, and then 24. Okay, you can submit this assignment on November 29. Okay, so thank you for listening. Good night.